This is Trey Wilson talking, and you may hear Craig Dowis chime in from time to time. And as a preface to this presentation, we've found over the years in talking to agents that through no fault of the agents or brokers, there was not much information or understanding about what litigation is. So for the first part of this presentation, we're going to talk a little bit about what litigation is, and that kind of transitions into some of the tips we're going to offer as to how to maintain your file such that if litigation does arise, you're in better shape. So that's our framework, so to speak. If you're trying to visualize Craig and myself, Craig has grown his hair out very much like Brad Pitt and Tristan, and I look a lot like George Clooney. So if you walk away with nothing else from this class, this is what Texas litigation against agents is all about. It is elementary school. It is yes you did, no I didn't. And what we mean by that is in litigation against brokers and agents, the party bringing suit is most often the buyer. And in this course, we're really focused on residential transactions. So you have the buyer of a home suing typically the listing agent, the listing broker, the buyer's agent, the buyer's broker, the inspector, the appraiser, the title company, et cetera, in kind of a shotgun format. And the typical complaints that a buyer will make are, yes, you did tell me X, Y, or Z about the property, and our agent's most common response to that is, no, I didn't. So with that framework, we're going to talk about the actual legal vehicle that plaintiffs most often use to sue agents, and that's called the Texas Deceptive Trade Practices Act. And I think you're going to be able to see how yes I did, no you didn't is really all that you have to remember about litigation in Texas. So this is the DTPA, or the Deceptive Trade Practices Act. It began as a lemon law back in the 70s to protect consumers against the used car salesman, and has now evolved into a pretty scary vehicle for bringing suits against all kinds of parties in transactions. And what it says is essentially an agent or a broker, and that's the example we'll always come back to, is liable if they engage in a false, misleading, or deceptive act that is a cause of the buyer's economic damages. And false, misleading, or deceptive sounds harsh and would sound difficult to prove, but the most common ways that that's framed in these cases are representing that the home has characteristics or qualities that it doesn't have, and that's what you see on your screen right now. The DTPA literally has a list of about, was it Craig, 25, 26?
26, 27.
Yeah, false or deceptive acts, and these are the three most common that we see. Number 5 and 7 talk about making representations, and then number 24 talks about withholding information that you knew about the property to induce the buyer into buying it. For instance, you become aware that the property has foundation issues, you don't tell them, and the theory is you're trying to trick them into buying the property in essence. So that's the backdrop of the DTPA. And if we come back to the theme of lawsuits against agents, which is yes you did, no I didn't, and again that's what you have to remember, how does that impact the way you practice real estate? Well, to understand that, you have to understand a little bit about how the legal system really works. Now, normally we'd be in a classroom asking these questions in the Socratic method and forcing you to answer it, so I may have to ask Craig these questions. But in Texas, we elect our judges. And for instance, in Dallas County back in 2008, we had a clean sweep where we got all new judges. And these judges come to the bench with their own backgrounds and their own political leanings and that sort of thing. And one misconception that a lot of people have about litigation and lawsuits are that judges decide who wins or who loses. Because the most common phone call that Craig and I get from agents when we first get a claim in is, hey, this claim, there's nothing to it, it's ridiculous, just get it dismissed. And there's this notion out there that that can happen. And we're here to bear a bad tidings that it just doesn't work like that. What judges do, they give the law to a jury. And we use Dallas County as an example, and the jury is either 12 people in district court or 6 people in county court. And I promise this is all going to come back to yes, you did, no, I didn't. And again, we'd ask this question, but to sit on a jury in Dallas County, you have to have, what, a driver's license.
Correct.
You cannot be a convicted felon. You do have to read and write the English language, and then you have to be alive. You have to have a pulse and working lungs. That's about it.
You have to fog a mirror.
You have to fog a mirror. And if any of you have been down to the Department of Motor Vehicles lately, that's your jury. That's your jury pool.
It's not a jury of your peers. There's not going to be other real estate agents or brokers on your jury. So that misconception we should probably address right at the outset.
Sure. The thought is that a jury trial is a jury of your peers, like Craig said. But there is a process, and some of you may have been through it, called voir dire or voir dire. In Texas, we say voir dire, where the plaintiff side goes through the process selecting the jurors that they want, and the defense side goes through selecting the jurors that they want. And in our experience, the plaintiff side will do what they can to eliminate from the jury pool any real estate brokers or real estate agents or someone who would sympathize with the plight of the agent being sued. So the jury pool you're left with likely will have no professionals on it who have a similar experience that you do, that being a license holder, someone who sells real estate. However, you may have someone on there who has had a very rotten experience with a home, and this is a fact that does not get kind of culled out in the voir dire process. So why does this matter? All right, so in district court you've got 12 people who are going to decide the facts of the case. They're going to decide who is more credible. And so if you could imagine having a dispute with someone, and the two of you are talking about how to solve it, and one of you said, tell you what, let's go down, let's pick 12 people, let's have them tell us which one of us is more believable or who is more credible. When there's money on the line or professional reputation on the line, not many people would choose that option, but that's what we have. So going back to the yes, you did, no, I didn't. In cases that we handle, Craig and I will try to get the case dismissed if it's appropriate to do so. And it is appropriate when the facts of the case are clear. When the facts of the case are clear, then the judge, and what we call a motion for summary judgment, or a fancy way of saying a motion to dismiss, can apply the law to those facts cleanly and easily. What judges do not like at that stage are disputed facts. And what's a disputed fact? A disputed fact is one side saying, yes, you did say that the foundation of the property was structurally sound, and the agent saying, no, I didn't, I would never say something like that. So yes, you did, no, I didn't is a disputed fact. Why does that matter? If there is a disputed fact, judges pass on the summary judgment motion or the motion to dismiss. And where does the case go from there? It goes to your 12 people or your 6 people who have a driver's license, and who can read and write the English language, and who, as Craig has said, can fog a mirror. And as attorneys, we know that amongst defendants, we are the number one most despised group of people on the planet, which is fine. We understand it.
We relish it.
We relish it. But agents are not too far down the list. So you're almost starting off behind when you get to the jury pool. And if all you have is the plaintiff saying, yes, you did, and you're saying, no, I didn't, there is really no one who can predict with any degree of reliability how that's going to turn out. So, with all that said, what can you give us, or what can you have in your file that changes, yes, you did, no, I didn't, to something different, and to something that we can work with, or the judge can work with, in a motion to dismiss? And the answer is simple: paper. If your file is documented, it takes away the yes, you did, no, I didn't dynamic from what we're dealing with and turns it into something more certain. For instance, I had a case in Grayson County where the plaintiff had bought a ranch property, and he was a very arrogant man who called me son, which is my least favorite thing to be called by someone who's not my father, I should say. And he alleged that the property that he bought, I wish I could show it to you, was effectively landlocked. There was not an easement, there was a disputed easement out of his property. And so he said to the agent that was sued, who we represented, you failed to disclose to me that this property had this easement problem. And my agent said, or our agent said, of course, no, I didn't. So we had yes, you did, no, I didn't. And we got documents through the title company that included emails where this doctor said, I can't recall who he was saying it to, but it was to the effect of, I know about this easement problem and I'll take care of it after closing. That document killed his case. So the document took what would have been a yes, you did, no, I didn't jury case to a case we could dispose of short of trial and short of the risk and expense of trial. So all of this is to say, if you document your file and keep important records and keep correspondence, you will put yourself in much better shape down the road, and you will avoid the yes, you did, no, I didn't problem. And before I transition to Craig, who's going to talk about some key documents that come up a lot in our transaction, just realize this: you cannot sell real estate like a lawyer, or you'd never sell it. Lawyers give things to society like warnings on capes that this cape does not enable a user to fly. So you have to take what we say with a chunk of salt, but that's why we're going to try to keep our tips simple and unobtrusive. So with that, I'm going to turn it over to Craig, and we're going to move through some documents.
Thanks, Trey. As Trey mentioned, documenting your file is by far the most important thing you can do in helping us, or whoever your counsel may be, in getting you out of litigation, avoiding costly litigation, and being successful on a motion for summary judgment, also known as a motion to dismiss. And that is our goal in every case where we represent agents, is to find a summary judgment issue. And in a lot of our cases, we are dealing with disclosure issues. That always plays a rather prominent role in our case. And unfortunately, real estate agents don't have the same level of protection that our legislature has afforded to doctors, for instance, or architects and engineers. But what they do have is they have certain promulgated forms in case law that has developed over the years that is very favorable to the real estate agent. And we're going to talk about several of the promulgated forms today, but the first form you have on your screen there is the seller's disclosure of property condition. This almost always plays a role in the case that we're defending. It is a critical form. It is critical that the initials appear on the form where they are called for, and it's critical that it's dated. And we'll talk more about that here momentarily. I think probably the most important representation that is being made through the form is at the very outset there. And I've highlighted it in yellow for you, and it clearly indicates in all capital letters at the very top of the form that it's a disclosure of the seller's knowledge. It is not a warranty of any kind by the seller's agents. And this is important because oftentimes you have very sophisticated clients who have purchased and sold numerous properties during the course of their lifetime, during the course of the transaction. But when they get into litigation, all of a sudden they become a fawn in the woods. They have relied upon you entirely. They trusted you completely, and they understood the disclosure notice as being your knowledge of the property, despite the fact that you've never lived there, never spent a single night there. And so at the very outset, this form states that it's the seller's knowledge of the condition of the property. And I mentioned a moment ago that the date is important. The reason the date's important is because we all know that the condition of the property can change over time. And so one of the things that Trey and I will often mention to our agent clients is it's important to have a relatively updated seller's disclosure notice. If your listing period has gone on for 6 months or longer, for instance, and the seller's disclosure notice hasn't been updated, it's not a bad practice to ask your client to update the seller's disclosure notice if an update is necessary. Because it's not only a protection for you, but it's also a protection for your seller. Now, there's 4 really big items that we see disproportionately in litigation. They're highlighted for you on the PowerPoint. And these are what we refer to as the big ticket items. The foundation/slab, previous termite damage, previous flooding, previous structural or roof repair. And more often than not, it seems the way these new purchasers find out about these defects that were not disclosed when they entered into the transaction is simply through talking with neighbors in the area. And the neighbor will say something along the lines of, "Were you aware of the flood that occurred here last year?" And the purchaser will always say no, and then the purchaser will immediately go and check the seller's disclosure notice and note on there that previous flooding was not checked. And so that's a common way that these new purchasers will learn that defects were not disclosed in the disclosure notice. And what your role as an agent is, you're not completing the form by any stretch. But what you do need to do is you need to give the form to your seller, make sure the seller reviews the form, completes the form, and initials, signs, and dates the form where appropriate. For instance, if the seller failed to disclose or failed to indicate yes or no on any of the points raised in question 4 on the seller's disclosure notice, as an agent, what I would expect you to do is point out that there's no indication one way or the other. And how do you do that? This gets back to what Trey was talking about in terms of documenting your file. The way you go about doing that is sending an email. Nobody really uses faxes anymore, and we want to have some record of a communication, a written communication, where you are pointing out to your seller that you have asked your client about completing all of the items in Section 4. Now, we've talked about the signature of the seller and in particular the date. The date's important based on that initial representation in the seller's disclosure notice. The signature of the seller, believe it or not, this seems rather elementary, but we've had litigation over this. We've had litigation where a husband and wife were selling a piece of property, and the husband signed the seller's disclosure notice, but the agent never had the wife sign the seller's disclosure notice. And so, believe it or not, we get into litigation, and then all of a sudden the wife, who did not sign the seller's disclosure notice, says, yes, I was aware of the previous flooding. I'm not sure why my husband wasn't, but I was certainly aware of it. And the agent, in haste, failed to notice that the wife did not sign the seller's disclosure notice, and the wife is now claiming in this litigation that had she signed the seller's disclosure notice, she would have reviewed it and determined that the indication as to no previous flooding was an error, made that correction. None of us would be here today. And so that's left pointing directly at the agent. That's one of the few instances in which the agent can get in trouble over a seller's disclosure notice. 9 times out of 10 in litigation, they are very helpful. In fact, they're usually the first document that we reference when we're arguing a summary judgment or when we're filing the motion for summary judgment. There's really 2 leading cases on the seller's disclosure of the property condition. And these are what I referenced earlier when I said the case law is very friendly or very favorable to agents. You've got the Sherman case and the Kabinski case. And I'm not going to bore you with reading what's in front of you there on your PowerPoint presentation. But essentially what they say is it's not what the agent knew with respect to the property, it is what the agent knew with respect to the property. It's not what the agent should have known, which is a different legal standard and a much more favorable legal standard for agents than it is for several other professionals. So they actually have to produce evidence that you knew of a property defect. The plaintiff's attorney can't come in and simply argue, well, there's a crack along the door jamb that's 2 inches wide, and therefore the agent, who's been in the business for 20 years, should have known that that's an indicator of foundation problems. Now, between us, I would hope that you would ask your client about something like that. But the case law says that unless they can establish that you had actual knowledge of the defect, we should prevail on summary judgment. And so that's something that's very favorable to real estate agents. Now, the intermediary relationship. It is one that the plaintiff's attorneys love to see, simply because it has the appearance of a conflict of interest. And there's several forms out there, and we'll talk some about the forms that really you absolutely need to have if you are entering into an intermediary relationship. The TREC has indicated that there's 3 successful or acceptable means of serving as an intermediary. I think we all probably know that dual agency has been prohibited for some time, and so that's certainly not one of the acceptable forms of serving in the role as an intermediary. Another thing is the broker technically is always acting as the intermediary. The agent is not technically the intermediary. The other thing that's important is you absolutely have to have the written consent of the parties indicating where the compensation to the broker is coming from. And I mentioned the forms. The forms where you're indicating where the compensation is coming from are always going to be the buyer's representation agreement and the listing agreement. Now, one thing we want to caution you on is oftentimes during the course of a transaction, the parties change. They're wearing different hats, if you will. where you may have started off, you and the broker may have started off serving solely as the listing agent. A month into the transaction, the broker may also be representing a buyer who's interested in purchasing your listing. And so when you have a situation like that, particularly when you have a situation like an intermediary, it's always critical to go back and check each and every one of your forms to make sure they're current with the hats the parties are wearing in the transaction. Now, the three approaches that TREC has blessed, the first one we have here is where Agent A is representing the seller, also had a buyer's representation agreement with the customer, but voided that buyer's representation agreement and now is simply working with the buyer as a mere customer. This is certainly not, in our view, a preferred method of handling the intermediary. I think we can probably all acknowledge that in your business as professionals, a large portion of your business is going to come from referrals. I think we can also probably acknowledge that you're not going to receive many referrals from the buyer as a mere customer because you chose to work instead with the seller. Having said that, this is one of the forms in which TREC has blessed. The second option is the broker serving as an intermediary. The broker appoints Agent A to work with the seller, Agent B to work with the buyer. In our experience, and again, Trey talked about the large grain of salt, and that's at least 100-pound grain, is it not?
It's a chunk, yeah.
It's a large chunk. In our preference, in terms of explaining the intermediary to a jury, this is by far what we like to see. It makes more sense. It's more difficult to argue that a conflict exists when you have one agent representing the seller, one agent representing the buyer. And so this is certainly our preferred method. And oftentimes, agents will team up with someone else in their office. We think that's a good approach because we know that intermediaries are common, and just break up the parties when you do have a situation like that. The third option, this one I paused because this one always, this is what causes me to lay awake at night and for my wife to yell at me for having the TV on at 3:30 in the morning. This is very close to dual agency, in my opinion. You've got the broker as the intermediary. The broker appoints an agent as the quote-unquote associate intermediary, and the associate intermediary is representing the seller and the buyer. In our experience, you really cannot provide the level of professionalism that many of your clients are accustomed to receiving when you have this relationship. Essentially, what you are doing if you were serving in the role as an associate intermediary is carrying water from the seller to the buyer to the seller. It's like a tennis match is all it is. You cannot counsel your clients on, or your seller on what you think the buyer will pay. You cannot counsel your buyer on what you think the seller will accept. You are limited to simply carrying numbers back and forth between the parties. And so because your role is so limited and because the appearance of a conflict is so clear, this is a difficult situation to explain to a jury who really doesn't have a good understanding of what an agent's role is in a transaction.
Yeah, well, this is all to say that since the intermediary relationship is so tricky and is often challenging to explain to a jury, because imagine the situation where, as the agent, your fiduciary obligation is to get the highest price you can for the property that you're listing within reason. And your fiduciary obligation, if you're representing the buyer, is arguably to get the lowest price that you can for the property, jurors will have a difficult time understanding how those two things can coexist. So we're about to transition into the documents that are important for this, but all of these approved TREC options are okay if they are documented, and that's really the key. And a quick example is we had a case, we always call it the no good deed goes unpunished case, where a sister had come into a lot of money, disposable income, through a divorce, and she was spending it like crazy. She bought, according to bank records, a couple of Tahoes in one day, one for her, one for a friend.
Everybody needs 2 Tahoes in one day, don't they?
That is true. And her sister, who is an agent, decides that she's going to blow through all this money. She's kind of mentally unstable. Let's get you investing in some real estate. But because it was a sister relationship, she did not, and what she was doing, I should say, too, is she was showing her sister properties that she was listing. And because it was her sister, she did not paper her file, as you would expect. There was no, and we'll get to these forms, but there wasn't a buyer's rep agreement. There was not an information about brokerage services document. And the sister bought 2 properties, ends up suing her sister, and in the case we go through all of the shortcomings in the file, but also all of the junk that these sisters had accumulated since they were children comes rushing out in this lawsuit, and it was the most unpleasant and uncomfortable experience ever to hear one sister still upset at the agent sister because she made cheerleader and the other one didn't. But only if she had documented the file, she would have been fine. And so with that, we're going to transition to the actual documents that will protect you if you, or really your broker, elects to go forward with an intermediary relationship.
The first form we're going to discuss is the IABS. Trey referenced it a moment ago in the sister litigation. One thing we're seeing an increase of in the past year or so is TREC complaints. And in each and every TREC complaint that we respond to, one of the very first, if not the first forms that TREC wants to see, you'll notice this is a form that's promulgated by TREC, and they love their promulgated form here. They want to see the IABS form. It's also important in litigation, however, because we get back to the point that we made earlier. You have a sophisticated buyer during the course of the transaction, but now the sophisticated buyer is a fawn in the woods and doesn't claim to know, particularly in an intermediary relationship, who's representing who. So this is a critical form for both responding to TREC complaints. It's absolutely necessary. It's also a critical form in litigation. So what we like to do is, you'll notice there's a place to sign for the client to sign and date down there at the bottom. But when you put this document in front of the plaintiff now in the course of litigation, they always say, well, yeah, I may have looked at it, but I didn't know which of the different hats applied to me. And so what we suggest you do is have your client circle or box off the relationship that applies to them in the transaction. And in addition to boxing that off, have the client place his or her initials there and also date when those initials were placed. And so, again, we're trying to tip the scales of justice in your favor on the yes, you did, no, I didn't. And that's one of the ways that we think we can do that. Now, one thing we need to caution you against is when you do have a situation where you have an intermediary and it has changed during the course of the transaction, make sure you go back and confirm that this form is accurate at the time that the relationships have changed.
And one thing you can do before we move to inspectors is in the listing agreement or the buyer's rep agreement, just be sure that when you are checking the boxes for what you're doing, you can always authorize in that form the intermediary relationship, and it's easier, I think, I don't know if you, Craig, just to go ahead and check it.
Yeah.
Unless there's a real resistance to it. And that way, that's in place because that also covers where commission's coming from.
Absolutely. Okay, the next form we're talking about, it's a TAR form. We're seeing these issues come up where someone's purchasing a property and choosing not to have a $300 or $400 inspection less frequently. Having said that, if you do have someone that's purchasing, say, a $200,000, $300,000 or more $100,000 home, and they're choosing not to pay $300 to $400 to have an inspection of the home, that should send off all sorts of red flags in your head. I don't care if their father was a contractor or their cousin's a contractor, or even if it's a new build, frankly. It needs to send off red flags because here's someone who's making a very large purchase, but yet they're unwilling to spend the $300 or $400 to get an inspection of the property. And what they always say in litigation is, well, I relied on my agent, or I relied on the seller's disclosure notice. And assuming the seller's disclosure notice is filled out completely, that's usually helpful. But I always recommend when you do have one of those rare instances that you use this form. We've highlighted some of the items here. The very bottom, I choose not to hire an inspector. The client signs and dates the form. Even if you're representing the seller, for your protection and also the protection of the buyer's agent, you probably want to see if the potential buyer will sign this form. Obviously, you have little control over what the buyer is going to do, the buyer being represented by another real estate agent, but it is for that agent's protection as well as your own protection to have a form like this signed. The purchase option law, we're going to really skip through that pretty quickly because as you can see, it's extremely, extremely dense. Trey had a client recently call from, I believe, the Bahamas.
Yes, always a call you want to take when someone's calling from the Bahamas. So.
And this client was interested in getting a contract drafted that dealt with the purchase option. The takeaway from the purchase option is it is extremely complex. The property code has several different sections, subsections, and
subsections.
Yeah, as many subs as you can think of, they're there. And so the takeaway from this is if your client is contemplating this, they absolutely need to seek the advice of counsel. That's one of those things where you want to email them if they're at all reluctant to seek the advice of counsel and document your suggestion in writing because it's just rife with potential problems. Now the subpoena. Many agents, when they get the subpoena, will simply bury their head in the sand because they don't want to get involved in litigation. No one faults you for that. But what you must do is you must report it to your office manager because subpoenas require relatively quick responses. And if you don't respond or if you the 20 days or however many days the subpoena is requesting you to produce documents or appear for a deposition or do both, and you choose not to respond, many of you, if not all of you, I hope, have E&O insurance, and your E&O insurance carrier can use that as a basis to decline your claim. So make sure that subpoena gets to your office manager as quickly as possible.
And we're going to run through some quick tips on how to maintain your file, and I want to talk about a real case real quick, where again we're talking about a buyer who purchases a property and subsequent to the purchase discovers termite damage. And the seller's disclosure says that the residence was treated quarterly for insects. The buyer claims that he never received the disclosure from his agent, and that if he had, of course, he wouldn't have bought the home because it would have alerted him to this possibility for termites. Now, this buyer's agent kept a good file, and he swore that he sent the seller's disclosure notice to the buyer as he had every other form. But when we looked in his file, this is back in the days of fax machines, he had every confirmation page except one. He did not have the confirmation page for the fax where he sent the seller's disclosure notice to the buyer. And we happen to believe that he did, but for whatever reason, he just didn't have that page stapled to the disclosure. So what does that mean? Well, if he had the confirmation page, then he could have proved that he sent the disclosure notice, case over. But since he didn't, now we're right back to the yes you did, no I didn't scenario, where the buyer says, you didn't send me the disclosure form, and my guy says, or our guy says, yes I did. That goes right past the judge to the jury, and now you're in the hands of 12 jurors. So that is a real world example of the importance of keeping things in your file. So how do you do that? If you still fax, I guess you should crawl out from the rock where you're living. We still fax, and be sure to keep the confirmation page attached to the correspondence. Email, of course, is the primary communication vehicle these days, and what we recommend is, well, first of all, email is great because if an issue does arise where someone is refusing to sign something, or like Craig said, you're trying to send something to the buyer's agent and recommend that they present it to their client, you always have an email basically verifying what you're trying to do. So what you want to do is you want to keep an Outlook folder identified by property or whatever's easiest, and you want to put all the emails related to that transaction in the folder. And that means all emails. And one thing we have seen is some agents will cherry pick the emails that they think is important, and what is important later, when we have the file, is often different than what may have been important at the time. And once the transaction closes, you want to put your whatever is easiest, but we recommend you drop your transaction folder onto a flash drive and you keep it. And a lot of you will work for brokers who have a document retention policy. We heard one yesterday that was 7 years. The statute of limitations under the DTPA is 2 years, but the trick there is it's 2 years from the time the buyer should have discovered the problem at the property. So it really is, we can't tell you it's a 2-year deal. They could discover a foundation issues 2 years after the closing. And the statute of limitations for fraud and breach of contract, which would be breach of a listing agreement, breach of a buyer's rep agreement, or even breach of the earnest money contract itself, is 4 years. So I think most offices are trending towards at least 5 years for hanging on to your documents. Like I said, please, we've got a few more things to cover, but as we're getting closer, go ahead and send your questions in so we can start formulating responses. Neither of us are the quickest on our feet, so we need time to let this marinate. Another big issue that we run into is how do you talk about a property? And under the DTPA, as it was constituted before the last legislative session, and we'll get to that real quick in a minute, you could represent something about a property that you believed in your heart of hearts was true. But if it turns out to be false, technically, under the DTPA, you can be held liable. So if you say, God forbid, the foundation of this property is structurally sound, there have been no problems, and it turns out there have been, you can be liable under the DTPA. The DTPA makes a distinction, an important distinction, between a representation and salesmanship language, or they call it puffing. We call it what? Romance language.
Yeah.
If you're puffing, and not inhaling. No, if you're puffing, you're not liable. If you're making a representation, you're potentially liable. So what's the difference? So this is a real case where an agent describes a property as superb, superfine, so it must have been in the 80s sometime, and one of the finest little properties in the city. And this was down in Austin. And normally we would force you in a classroom to tell us what you think. And since we know the answer, there really is no drama here. But the court found that this was a this was puffing. I'm sorry, golly, this was puffing. And the reason is that the distinction is the more specific you are, the more likely the court will say you're making a representation. Whereas if you're being a little vague, superb, superfine, not just fine, but superfine, you're safe. Or are you? Here's another example. This is a real case. An agent describes a townhouse unit as an extremely well-built 2-bedroom townhouse. Now here, the court, a different court, and there are different courts, there are 14 different courts in Texas where we cull our law from, 15 if you count the Supreme Court, said that's representation. And I can only think that well-built ascribes some quality to the property that superfine does not, I guess.
Yeah, and Trey's mentioned this. Be cautious about describing the structural capabilities of a property. That's really where you get in trouble on the romance language.
And then this is an example we pulled from the MLS. Gorgeous interior finish out with exclusive high-end choices. There is no answer to this, but we usually get a mixed answer in our classes because of high-end. This is probably puffing. But this is just to illustrate that it depends where you are in Texas. In Dallas, this is probably puffing. In the Valley, it's a representation, and they'll, hit you for $1 million and take your home from you. So our recommended practice, like Craig said, is avoid characterizing the performance of the elements in the residence. You can say what it is, but just don't say how it's doing. This is a 30-year roof or whatever the industry lingo is, but you don't want to also say, and it's never leaked. So careful out there. We do like to close with a section. We'll do this very quickly, and then we'll take questions. I think there are 2. So someone out there is playing Halo or something, I'm not sure. But the texting, we get this question a lot. One is, how do you capture a text? And we're going to start this conversation by saying there was a day when we wrote letters. And letters were great because by the time you sent the letter, it was exactly what you intended to say. And then we moved to the email, and we start to get a little loose. And recall that our goal at a trial, and that's always how Craig and I are thinking, is how to do this at trial, is to present you as a professional. And it is difficult to do that if you use casual language in an email. And the mother of all casualness is the text. And if you use shorthand, if you are a teenager when you text, and you're LOLing all over the place, or using shorthand that includes curse word references, God forbid, those get blown up. And a quick example I have is, this is a case we have right now. There's an email string amongst the buyer, the listing agent, the builder of a home, the title company, and the lender. And they're dealing with the buyer's agent and the buyer, and it's a very professional email string until one person breaks rank and calls the buyer's agent, believe it or not, or the buyer, crazy. She's a crazy woman. And then the dog pile starts, and there's a string of about 5 or 6 emails where they're saying how crazy this person is. Well, of course, that case goes into litigation, and now the plaintiff's lawyer has this email string where he can demonstrate that these people were not taking this issue seriously, and in fact, they were calling her crazy. So if you can get loose with an email, we all get loose with texts. And as my father-in-law would say, or has said to me, don't send anything unless you're comfortable reading it Sunday morning at 11 o'clock to the congregation. So be very careful with how you communicate. with text. How do you capture them? Craig knows something about this.
Yeah, there's different ways you can capture the text messages. I know you can take a picture of them on certain phones, and then you'd want to download them into your email folder for the particular transaction. And I believe on other phones you might be able to email them directly to yourself. If you've got an IT person, we're certainly not that computer savvy, Trey and I. Talk with your IT person and see what you can do to capture your text message, because we need those. We need some written communication in your file, and oftentimes we know we're moving towards text, and so we'll need to have those captured.
And I should close by saying one consequence of not preserving your file, and Craig can speak to this real quickly and then we'll get to questions, is if you're producing your emails in a case, at a subpoena or in a case, and you give us 20 emails, and we know there are more like 100, and your client or the other side starts producing emails that you have not located and handed over, the judge can order that your laptop or computer be submitted for a forensic exam at your cost, and they go through everything. And then your broker's server may be searched. So there is a real consequence, or there can be, to not maintaining your file properly. So with that, we're going to take some questions. And
the first question, Annette, it's in the case of a relocation, how does a seller's disclosure come into play? Well, I know the property code sets forth specific instances or limits the instances in which a seller's disclosure does not come into play. I haven't looked at it recently, so this will be off the cuff with respect to this question. I do not think the property code says in a relocation situation a seller's disclosure notice is not necessary. What I would recommend is if you don't have the seller of the property, if you don't have the owner of the property complete it, maybe the relocation company completes but indicates on the form that they have no knowledge of the condition of the property, they are not the owner of the property, they are not occupying the property, and this is what's critical, in the special provisions portion of the contract, of the property contract, indicate there that a seller's disclosure notice has been completed. You do not intend for the buyer to rely upon the seller's disclosure notice, and you strongly encourage the buyer to obtain an inspection of the property.
And before we move on to the next question, I'll add, too, that regardless of what is required by the property code, just remember that for an agent, if you have actual knowledge of a condition that exists at the home,
right,
you still have an obligation to disclose that, as does the seller.
Yeah.
So even the seller's disclosure aside, there is that obligation out there. So our next question is, I don't have my glasses, so Craig may have to.
Okay, the next question involves a buyer only wanting to fix certain items with the home after the inspection has been performed, and how the buyer's agent should avoid litigation when you have a situation like this. More often than not, what we're seeing cash in lieu of repairs. But if you do have a repair amendment where actual repairs are being performed, I strongly encourage you to encourage your buyer to have a contractor go to the property after having received the inspection report and provide an estimate for what the contractor thinks it will cost to get the specific items repaired. And even if you still want to repair the specific items in lieu of receiving cash, you can do that but your buyer's going into it knowing what the items will cost, and then you need to be very specific, referencing both the inspection report and the contractor's estimate on the repair amendment as to what items you want repaired. And then at the end, you need to do a walkthrough.
The next question.
The next question involves an intermediary relationship. It's a small brokerage with one broker and one agent. And whether the broker can appoint herself as an associate to represent the seller and the other agent to represent the buyer. Short answer is no. I wouldn't. You can't use that preferred method. You could use the buyer as a mere customer. That was the first example that we looked at. Or you could use the one that keeps us up at night. The third example, where you have an associate intermediary, and in that case, you would have the broker, and then you would have the associate intermediary, the licensed salesperson, and then the associate intermediary would represent both the seller and the buyer.
And of course, even though that gives us heartburn, that's okay if it's documented. And there's another form that is out there. It's the TAR,
Yes.
Notice of Intermediary Relationship form. That if you find yourself opting for that third option, just be sure it's papered. And if it's papered, you're probably in good shape.
Yeah, keep in mind that less than 1% of the transactions that your profession does end up in litigation. And so, again, large grain of salt. If you document it, you should be fine there. The final question that we have right now is...
May I read it?
Sure.
It says, is it a good practice for an agency to use its own form in addition to the ABS form in order to detail agency relationship with buyer and seller and have those parties sign that form to indicate understanding of the relationship?
Okay, so this question relates to doing something in addition to the IABS form. I agree. This needs to be done if you've got an agency form in addition to, and certainly not conflicting with, the IABS form that further explains the relationship of the parties. That's a very good idea, particularly when you have the intermediary. You'll notice on the last page of the property contract, you indicate who the parties are representing on there, but that's also the only page of the contract in which the parties do not sign or initial. And so anytime you can indicate on more than just the IABS form and have a signature of a client indicating that they acknowledge the representation, I think that's a good idea.
Now, let me just close with one more real-world example that we've had where it was an intermediary issue where the broker assigned salespeople from the same office to represent the different parties. And like Craig has been saying, we can't emphasize enough that regardless of what your buyer was like in the transaction, when they become a plaintiff in the lawsuit, they suddenly can't read, and if they can, they don't understand it. So the more documentation you have, the more signatures or initials and that kind of stuff. And in this case, they were disputing that they were advised that there was an intermediary relationship going on. And in that case, we had the TAR form, which is a great form, the Notice of Intermediary Relationship, as well as the information about brokerage services document. And that case was thrown out. And it demonstrated to me the power of having your documents in order. So if there aren't any more questions,
great.
We're good to go.
Thank you for attending the webinar.